Hello everyone, hope you are doing great. I am Arjun Chowdary and I welcome you all to this channel, India Insights. In today's video, we explore Writ Petitions, a powerful tool that empowers citizens to seek justice when their rights are violated. Whether you are a law student, a professional, or just someone interested in understanding your rights, this video will guide you through the types of writs, how to file them, and the benefits that they offer. So, let's get started. What exactly a writ petition is? In simple words, a writ petition is a formal written request filed before a court, particularly the High Courts or Supreme Court, to issue specific orders in cases where the fundamental and legal rights are infringed. Under the Articles 32 and 226 of the Indian Constitution, citizens can approach the courts to issue writs when their fundamental rights are violated. And now, what is a writ? A writ is an order issued by a court directing someone to perform or refrain from performing a specific act. The primary purpose of writ is to ensure that the fundamental rights of no individual are violated. These writs ensure that the authorities stay within their jurisdiction and uphold the law by reinforcing the principles of justice and accountability. In India, there are mainly five types of writs: Habeas Corpus, Mandamus, Prohibition, Certiorari, and Quo Warranto. Let's explore each of them in detail. If we go to the historical background, the concept of all these writs dates back to the English common law. Over the time, these writs have been incorporated into various legal systems around the world, including the United States and India. And now, coming to the habeas corpus writ. The term habeas corpus is a Latin word and it means you shall have the body. The primary purpose of this writ is to prevent the government or any authority from detaining the individuals without any valid cause. It upholds the principle of personal liberty by ensuring that no one is held without a legal jurisdiction. Now, who can file this petition? The individual who is being detained can file this writ petition. The next of kin or the family members of the detainee or the legal representatives can also file this petition on behalf of the detainee. A writ of habeas corpus can be filed on several grounds, like the lack of a jurisdiction, which means the detaining authority did not have the legal power to detain the individual, or if the detention violates the constitutional right of individuals, such as the right to liberty and due process, or if the proper legal procedures for arrest and detention were not followed. In all such cases, a writ of habeas corpus can be filed. How does the habeas corpus writ exactly works? A person who believes that they are unlawfully detained can file a writ of habeas corpus in a court. If the court finds sufficient grounds, then it issues the writ, directing the custodian or the authority holding the detainee to produce him before the court. The court then conducts a hearing to determine the legality of the detention. The custodian must justify the detention of the detainee. And finally, if the court finds the detention is unlawful, then it orders the release of that individual. While this habeas corpus is a powerful tool, there are some limitations also for this. In times of national emergency or war, some jurisdictions may suspend the right to habeas corpus, and the individuals detained under certain laws, like preventive detention, may have a limited access to habeas corpus. So, this writ acts as a check on the powers of the state by preventing the arbitrary and unlawful detention of the individuals. It provides a swift legal remedy for individuals who believe that they are wrongfully imprisoned, and it upholds the freedom of individuals and the rule of law in a democratic society. Second is the writ of mandamus. What is writ of mandamus? Mandamus means we command. This writ is a legal order issued by a court compelling a public authority or a government official to perform a specific duty that they are obligated to perform under the law. The primary purpose of this writ is to compel a government official or authority to perform a statutory or public duty that they have failed to execute. This writ ensures that individuals or entities can enforce their legal rights when they are not being acknowledged or acted upon by the authorities. And now, who can file this writ of mandamus? Any person who has a right that has been denied can file a writ of mandamus. And in case of organizations, groups or entities can also file the writ of mandamus on behalf of their members and in the interest of their organization. A writ of mandamus can be filed if there is a clear and specific duty that the authority is required to perform but failed to act upon, that or has delayed action unjustifiably, or if there is no other adequate legal remedy available with the petitioner, then in those circumstances, this petition can be filed. How does the writ of mandamus work? Any individual or entity who believes that a public authority has failed to perform a mandatory duty can file a petition for the writ of mandamus in an appropriate court. If the court finds that the petitioner has a clear legal right to the performance of the duty, then the court will issue the writ. And then the authority must comply with the orders of the court and fulfill their legal obligations. There are some limitations for this writ. It only applies to the mandatory duties. It cannot be issued to compel an authority to exercise discretion in a particular way. And if the matter is still under consideration by the authority, then in such case, mandamus may not be issued. This writ cannot be used to compel an action by any private individuals or entities. The writ of mandamus holds public authorities accountable for their actions or inactions by ensuring that they fulfill their duties. The writ protects the legal rights of the individuals and ensures that justice is not delayed due to the bureaucratic inaction. It reinforces the role of judiciary in reviewing and enforcing the actions of the executive and administrative bodies. Next is writ of prohibition. Writ of prohibition is a legal order issued by a higher court to a lower court or tribunal, directing it to refrain from proceeding with a case or a particular action that exceeds its jurisdiction or authority. This writ stops a lower court from acting in a way that violates the law. The primary purpose of this writ is to prevent the lower courts from exceeding their jurisdiction or acting beyond their legal authority. It ensures that rule of law is upheld and that the judicial functions are carried out within the bounds of the law. And now, who can file this writ of prohibition? Any party involved in a case before the lower court can file for a writ of prohibition, and the concerned individuals who believe that they may be affected by the actions of the lower court can also file this writ of prohibition. A writ of prohibition can be filed if the lower court does not have the authority to hear the case or make a ruling on the matter, or if the lower court is following procedures that are not in accordance with the law, or if the action of the lower court may violate the fundamental rights of these individuals. In all these cases, a writ of prohibition can be filed. How does the writ of prohibition work? A party who believes that lower court is about to act beyond the jurisdiction can file a petition for writ of prohibition in a higher court. If the higher court finds that there are sufficient grounds to support the claim, then it will issue the writ prohibiting the lower court from proceeding with the case. Then the lower court must comply with the writ and refrain from taking further action in the matter. And now coming to the limitations of this writ, this cannot be issued as a substitute for an appeal. This is meant to prevent actions rather than correct them after they occur. The higher court has discretion in deciding whether to issue the writ, and it may deny the request if it finds no sufficient grounds. This is generally not available for interlocutory matters, which means the issues that arise during the course of a trial. So, the writ of prohibition acts as a tool for higher courts to exercise oversight over the lower courts, ensuring that justice is administered correctly. The writ helps maintain the separation of powers by ensuring that courts do not overstep their boundaries. By preventing the wrongful judicial actions, it protects the rights and interests of the individuals. Number 4 is the writ of certiorari. This writ is a legal order issued by a higher court to a lower court or tribunal, directing it to send the records of the case for review. This writ is used when a party seeks to challenge a decision made by a lower court, and it allows the higher court to evaluate the legality and correctness of that decision. The primary purpose of this writ is to facilitate the judicial review, allowing higher courts to oversee and correct the decisions of the lower courts. It also enables higher courts to review cases for potential errors in the application of law, procedure, or constitutional rights. Who can file this writ of certiorari? Any party involved in the case, such as the plaintiff or defendant, can file the writ of certiorari, and the individuals or organizations that may be affected by the outcome of the case can also file this writ. A writ of certiorari can be sought if the lower court made an error in interpreting or applying the law, or if the decision involves important constitutional questions or interpretations, or if there are any conflicting decisions among the lower courts on similar issues. How does the writ of certiorari work? Any party not satisfied with the decision of a lower court can file a petition for a writ of certiorari in a higher court. The higher court then reviews the petition by assessing whether there are significant legal questions or issues at stake to determine whether it warrants a hearing or not. If the higher court agrees to hear the case, then it issues the writ of certiorari, compelling the lower court to send the case records. And finally, the higher court conducts a hearing to review the decision of lower court and can either uphold, reverse, or modify that decision. If we come to the limitations of this writ, the decision to grant the writ of certiorari is discretionary. Petitions may be denied without any explanation. Certiorari may not be applicable in some cases if the decision of lower court is deemed final. The higher court focuses on legal questions and does not completely re-evaluate the factual findings of the lower court. So, the writ of certiorari helps maintain consistency in legal interpretations across different jurisdictions by allowing higher courts to review and clarify the legal principles. The writ serves to protect the rights of individuals by ensuring that lower courts do not violate legal standards or constitutional protections. It reinforces the role of higher courts in supervising the functioning of lower courts and safeguarding the integrity of the judicial process. Now, the writ of quo warranto. This is a legal order issued by a court to an individual or entity challenging their right to hold a public office or exercise authority. The term quo warranto means by what authority, and it seeks to determine whether the person or entity has the legal right to act in a certain capacity. The main purpose of this writ is to prevent the individuals or entities from assuming or continuing in a public office without the legal authority to do so. It ensures that only those who are legally entitled to hold a position to do so, thereby maintaining the integrity of public offices. And who can file this writ of quo warranto? Any citizen or interested party who has a legitimate interest in the matter can file for a writ of quo warranto. But in some jurisdictions, only certain competent authorities may have the right to file this writ. A writ of quo warranto can be filed against the individual if it does not have the legal right to hold the public office, or if that person was not properly appointed or elected according to the applicable laws, or if that individual violates any specific statutory requirements for holding that office. How does the writ of quo warranto works? A person or entity who believes that someone is unlawfully holding a public office can file a petition for a writ of quo warranto in a competent court. If the court finds sufficient grounds, it issues the writ compelling the individual or entity to justify their claim to the office or authority. Then the court conducts a hearing where the respondent must prove their rights to the position. If the court finds that the respondent does not have a valid claim, then courts may order the removal of that individual from the office. Coming to the limitations of the writ quo warranto, it applies only to the public offices and cannot be used to challenge private positions or authority. And the courts may exercise discretion in granting the writ, and not all petitions may be accepted. There may be some time limits within which the writ must be filed after the individual takes the office. So, the writ of quo warranto holds public officials accountable, ensuring that they cannot abuse their authority or remain in office without the proper justification. It helps maintain the integrity and credibility of public offices by ensuring that only qualified individuals hold them. The writ serves the public interest by preventing mismanagement or misconduct by those in positions of power. And finally, to sum it up, writ petitions are a powerful way to seek justice and protect your rights. They are vital for maintaining the rule of law and ensuring that authorities do not misuse their powers. If you ever find yourself in a situation where your rights are being infringed, remember that writ petitions are there to help you. Thank you so much for watching. Don't forget to like, share and subscribe this channel for more legal insights. Thank you so much. Jai Hind.